I move adoption of the minute.
Thank you. Second with Representative Mon. Any discussion on the approval of minutes? Okay.
I close.
Thank you. All those in favor of approving the minutes for those dates that we listed, say aye. Aye. Opposed, no. Well, is John Carmichael sitting next to me? Sorry. Did you like your vote recorded?
Madam Chair, I was paying no attention whatsoever, but I'm glad the minutes were approved. Thank you.
Okay. Thank you all very much. I appreciate that. Okay, we're going to go ahead and jump in. As I mentioned from the well, we do have a good bit of work to do today. And we are going to start with working Senate Bill 500, which is the bill that we heard yesterday. And so we'll start with, do we have any amendments? Representative Titus.
Thank you, Madam Chair. I have an amendment if Natalie would pass it out. But in summary, what this amendment does is it undoes one of the amendments that was put in by undoes, right? Undoes. It's KU. What do you expect? Anyway, it removes the Senate amendment about the payment plans, and this is in response to the testimony from the Supreme Court about how there was some ambiguity in the terms, how it would apply. And I offer this not necessarily wholly against clarifying when payment plans can apply, how they can work. But given the short amount of time to work on this, I thought it would be best to just remove this. Gives us a clear position in conference, and the wise chair, vice chair, and ranking can sort out the best pieces for a payment plan. So with that, I would move my amendment.
Do we have a second? Representative Bourgeon, second. Okay, committee, do you have any questions or comments on the amendment to House Bill 55? Representative Carmichael.
Thank you. If I might inquire of the maker of the amendment, Ms. Bayless, I believe on behalf of the court, expressed several different concerns yesterday, and I wasn't paying careful enough attention or making notes. Does this address, do you think, all of the concerns she expressed, or is this only a partial fix to what the court said they needed?
I think most of it, but I'm not comfortable saying all.
I appreciate your quandary and I appreciate your help. Thank you.
Are there any other questions or comments on the amendment? Okay, Representative, you may close. Or I'm sorry, Representative Curtis.
Thank you, Madam Chair. It took me a minute to kind of think it through here. I thought one of the major problems that they had in part was that they preferred the language compliance with order of the court. And then I think one of the other issues that they had was just the timeline in which they had to implement it. So I guess I'm a little bit concerned that we throw out the whole thing, because you're removing, correct? You're removing the whole payment part. Is that right?
So yes, but it does still allow for it restores, it removes, but it puts back in the bill as introduced. So there is language in the original bill that says if hardship is shown, they could. So if it went through as originally introduced, they decided not to change it in conference, there's still the opportunity for payment plans. And I think we had testimony that they do give payment plans. There's just the limits on the payments and some of the time served, and some of that doesn't calculate into it.
Okay, and so your amendment just deals with the payment plans and not any of the other issues that they brought up. Is that correct?
It also does. So it's the hardship payment plans. It also deals with where they would get community service credit. It also removes that piece of it, but yes.
Okay, thank you.
Any other questions or comments? Okay, Representative, you may close.
I close.
Committee, you've heard the motion to amend House Bill 500. All those in favor say aye.
Aye.
Opposed, no. Okay, House Bill 500 is amended. And now we are on the bill. Do we have any motion on the bill? Representative Mon.
Madam Chair, I move that House Bill 500 or Senate Bill 500 as amended be passed out of committee as amended.
Do we have a second? Representative Titus seconds. Okay, any discussion on this? We just heard it yesterday, so we didn't get a review, but does anyone have any questions either for anyone on the committee or for the revisor about it? Okay, then Representative, you may close on your motion.
Thank you, Madam Chair. I close and ask that the committee approve the motion as stated.
And the bill as amended. Yeah.
Yes, that the
Motion.
bill be approved as amended out of committee.
Okay, thank you. You have heard the motion to move to pass Senate Bill 500 favorably for passage as amended. All those in favor say aye. Opposed, no. Okay, thank you. Yes. Representative Carmichael is a yes and Representative Heiberger is a yes. Okay, thank you. Okay, committee, we are now going to hear Senate Bill 379. And Natalie, could you give us a refresher? It's been a while since we heard that one.
Sure. Thank you, Madam Chair. Senate Bill 379 provides a longer time for notice to creditors by publication when a petition for administration of probate of a will is filed. It also changes the process for transferring personal property by affidavit in small estates, and it modifies the time requirements for notice by publication related to sales at public auction. All of that's done within the probate code.
Okay, thank you. Does anyone have any questions for the revisor? If you all recall, I think there was one proponent for this bill, and it was the former chairman of the committee. I was very sorry to miss that. I hope you all gave him a really good time for that bill. But okay, are there any amendments for that one? Anyone have anything? Okay, then do we have a motion on the bill? Representative Carmichael.
I move that we report out SB 379 favorably for passage.
Representative Lewis seconds. Discussion committee on that one. Okay, no discussion, so Representative, you may close.
Thank you, Madam Chair. This is fine legislation. I close and move my motion.
Thank you. Committee, you've heard the motion to pass Senate Bill 379 favorably for passage. All those in favor say aye. Opposed, no. Okay, we have now passed out also Senate Bill 379. And Representative Heiberger would like his yes vote recorded. Representative Carmichael voted yes on his own motion. Okay, very good. Okay, committee. We're now going to hear Senate Bill 265. Do we have amendments on that? Representative Schreiber. Oh, I'm sorry. Natalie, could you give us a refresher on that Senate Bill 265 real quick? Thank you.
Thank you, Madam Chair. Senate Bill 265 requires a person who's convicted of an offense that results in the death or incapacitation of a victim who's the parent or guardian of a minor child to pay restitution in the form of child support for those children. And it also increases the criminal penalties for repeat violations of a protective order.
Okay, thank you. Representative Schreiber, would you like to offer your amendment and explain it, or okay? Okay, very good. Thank you.
Okay, can I go ahead?
Yes, Representative Schreiber.
Thank you, Madam Chair. So this amendment, it does strike new section 1, which was put in the Senate, and I think had a couple of comments in testimony. Excuse me. Then on, let's see, where am I at? Okay, then on the large addition at the bottom of the third page, there's language added that except that no fee shall be charged for serving, executing, and returning any process, on and on. This was brought forward by Michelle McCormick at the Kansas Coalition Against Sexual and Domestic Violence. They were wanting some assurity and statute that there are no fees charged on these protective orders because the Violence Against Women's Act funders at the federal level, which provides a lot of their grant funding, wanted greater surety in our statutes that there are no fees, although it was kind of implied in the original statute there, but this would make it crystal clear. The other sections that are deleted, there's some statutes that are deleted there, and those are just to kind of true up the rest of the document. Madam Chair, I think that's pretty much, I'll just take questions then.
Okay, thank you. I did have a question. So just to make sure I understand, of course, the sheriff is not charging a fee to serve for process serving. But if it was a private process server that had to be used, we can't keep them from charging a fee. Is that correct?
Yeah, that's my
That,
understanding.
yeah, okay.
Yes.
Just making sure that that was clear in here.
It was county law enforcement.
Okay. Okay. Other questions or comments on the amendment you all have for the representative that brought the amendment or for the revisor? Okay. Then I guess Representative, you may close.
I'll close.
Oh, we didn't have a second on the motion. I'm sorry.
Second it too. No, just kidding.
Representative Bourgeon. The motion by Representative Schreiber, second by Bourgeon. Representative Bourgeon. Okay. I'll ask again. Is there any discussion since that's where we're at now?
Just thinking, as the interim ranking member of the that needs to at least support our Democratic compatriots on the Senate side, I'll say no, please don't. Thank you.
Such sincerity.
Okay, thank you. Any other comments? Okay. If not, then Representative, now you may close.
And I close.
Thank you. So committee, you've heard the motion to amend Senate Bill 265. All those in favor say aye. Aye. Opposed, no. Thank you. So we do have an amendment on Senate Bill 265. Representative Carmichael.
Yeah, I better take credit for that yes vote. I'll have to explain it, I'm sure, to my colleagues in the Senate, but it was much more important that we deal with that fee than the Senate floor amendment.
Thank you. So you are a yes.
I'm a yes.
Okay, very good. Okay, do we have a motion on the bill? Where is Representative Hoheisel when I need him? Yeah, Representative Curtis. I'm sorry. Oh, okay. Just one. I'm sorry. I'm calling on the revisor because there is a technical amendment that I.
Thank you, Madam Chair. As this came to you from last session, you'll see there's a lot of references to SUP updates that are out of date. So we do have a technical amendment.
Thank you. And as Natalie's passing that out, as she mentioned, it's a technical amendment. I'll go ahead and offer that amendment. And do I have a second on that? Representative Schreiber? Seconds. Was there any other explanation you feel like, Natalie? Okay. All right. Any discussion on the technical amendment? Okay, I close on the amendment. All those in favor of the amendment in front of you on Senate Bill 265, say aye. In favor of? Opposed? No. Okay, so we have two amendments on Senate Bill 265. Are there any other amendments? Okay, do we have a motion on Senate Bill 265? Representative Goddard.
Thank you, Madam Chair. I move to move Senate Bill 265 out of committee, favorable for passage. As amended, that's right. Thank you.
Do we have a second? Representative Schreiber, second. Okay, committee, any discussion on this one? Okay, seeing none, Representative, you may close on your amendment, on your motion.
Madam Chair, I close on the amendment and the motion.
Thank you. Okay, committee, you've heard the motion to approve Senate Bill 265 favorably for passage as amended. All those in favor say aye. Aye. Opposed, no. Okay, so we have now passed Senate Bill 265 out favorably for passage, also as amended. And Representative Carmichael and Heiberger would like their yes vote recorded. Okay, committee, it gets a little more complicated at this point. We had a Senate bill referred to our committee this morning from the Child Welfare Committee. It was Senate Bill 232. And that's just note that. I have an amendment for Senate Bill 232, and Natalie will pass it out, and I'll explain what it is. I tried to get around and speak to several of you about this so you know, because it's a little bit different. It is taking the contents of House Bill 2299, which we heard in the Child Welfare Committee and for actually several times and in the Senate also. And it is placing the contents of House Bill 2299 into Senate Bill 232. I have copies of House Bill 2299 if people would just like that straight up copy of the bill. Okay. Yeah. It's printed in the entirety here in the amendment also, but sometimes it's just easier to look at in the booklet form. Committee, the reason that would like to do this is because it's a bill that we've had in child welfare. It's sitting under the line on the House right now. It probably does need a few tweaks to make it completely favorable for most people. And if it's not in a Senate bill, it won't go anywhere this year. A lot of people have been working on it. There was a Judicial Council committee that worked on this topic, and they came up with suggestions. They didn't have a bill, but they came up with suggestions. Most of the suggestions are incorporated into House Bill 2299. So it has to do especially with taking attachment into consideration when a decision is being made for an adoption resource. And it asks the court, or it asks DCF to take, if a child has been in a foster home for 2 years or more, or has been more than half their life with a foster family, it asks DCF, the agencies, to consider that foster family as an adoption resource. And it also takes into account, of course, the best interest of the child. And I will, in a minute, ask Representative Concanon to also give us her take on it, if you don't mind. But your buttons, okay. So I'll go ahead and let her give you more. And please ask any questions that you have. But I will move my motion to amend Senate Bill 232 as spoken about. And I'll call on Representative Concanon. Oh, I need a second. Representative, Neely. Sorry, forgive me. Seconds. Representative Concanon. I'm sorry, Vaughn. Yeah. Representative Vaughn. Sorry. Yes.
Madam Chair, I just wondered in this situation if it's okay for the reviser to give an overview of the bill or how that kind of works, if she has kind of the reviser's information on 2279.
2299. Please do that. Okay, well, if you don't mind, while the reviser is taking a look at that, Representative Concanon will explain why Senate Bill 232 is available to us, because there's two parts to this, right? Senate Bill 232 and then also House Bill 2299. So, Representative Concanon.
Thank you, Madam Chair. So if you look at this bill, it might pop out at you because it's establishing the Office of the Child Advocate. This is the Senate version of that bill, and that the Senate took the contents of this bill and put it in a House bill, and that House bill is currently in conference. So this bill was in my committee and available to use. So that's why we don't need this version.
So that's the one part of it. And then Natalie, do you feel like you could give us an overview of House Bill 2299? I know that's wasn't in your committee, but if you feel like you can, that'd be great.
Madam Chair, I do not feel competent to be able to give you that overview. However, I was just chatting with Natalie Nelson from Research. I think she also staffs that committee. And I think we could maybe work with Research to get the subnote available to you guys, and maybe we could print it and distribute it, because even our reviser's bill brief will be a little outdated because there were some amendments made in committee, so those wouldn't be incorporated. So
I'm passing around the set notes.
Okay.
Yeah. So I'll give you all just a minute to look at that, if you would like that. I will mention also that the language of House Bill 2299 was put into a bill that the Senate heard on their floor. And so the Senate took this language and put it in a bill that they passed across their chamber last year. So they have seen it, they've passed it, but it's in Senate Bill 232. Okay. They put it in with their Office of the Child Advocate bill. Now, if y'all aren't confused, then you're doing I want to make it clear exactly what we're doing. I don't want it to be anything anyone has a question about. But yes, Representative Osmond.
Thank you very much, Madam Chair. I'm currently agnostic as it relates to 2299 because we're all still reading through it. So I don't know how I feel about the bill itself. My concern is that the bill, we have not heard in Judiciary. We've not had testimony in Judiciary, and it's coming to us from another committee. But when it comes down to it will eventually then either go to the House floor and be conferenceable, in which case it still won't get debated on the House floor. It'll become an up and down vote. And that's generally my concern, is that we may be passing something out that we don't really either fully understand or haven't fully vetted. And I realize maybe another committee has, but we haven't. And then it goes that it most likely will not get debated on the House floor. It will become conferenceable and then put into another bill that will eventually go to an up or down vote at some point in the future. And I'm just concerned about the process that I don't know. I won't know at any point through this process whether it's a good or bad bill objectively.
Representative Carmichael.
Thank you, Madam Chair. I will attempt to measure my words carefully. I think this is a serious mistake. In the 10 years that I've been on this committee, I cannot recall another occasion other than corrections, which is sort of our sister committee, but where legislation from another committee that we have never heard, that we know nothing about, that our revisor can't even brief us on, is brought into the Judiciary Committee, and we're told this is a good idea from another committee. And as I understand it, it didn't ever get above the line. So we're going to take this idea from another committee and we're going to stick it into a bill in the House Judiciary Committee. That is not the committee process. That is not regular order. I haven't read either one of these bills, and looking at a subnote isn't going to cure that. Before I in committee vote in favor of a bill, I do my very best to, one, listen to the committee testimony, two, ask questions of the conferees to clear up any misunderstandings, and three, read the committee testimony. This committee hasn't had an opportunity to do any of this. This is not a good idea. Thank you.
Do we have any other discussion? Representative Owens.
I have gotten just a little bit lost. Can you clarify exactly where we are in the process? Is there a motion on the floor and maybe restate it for me?
Yeah, there's a motion on the floor to amend Senate Bill 232.
And to insert the contents of 2299, is that?
Yes.
Just making sure that okay, just wanted to make sure.
That's where we are right now. Any other discussion? Representative Curtis.
I just want to echo a little bit of the thought that my colleague has about this is not a bill that's been in our committee. This is not a bill that I feel I could make a good informed decision on at this time. For the same reasons that he has stated, so I don't need to restate them, but I don't feel comfortable with this at all.
Representative Neely.
I don't know if this is even the right time to ask, but I wanted to ask Concan and everything in the committee and everything, if this bill was brought about in regards to a specific case in which perhaps my area.
Representative Concanon.
So that's been talked about quite a bit with this case because I guess maybe unfortunately it happened at around the same time. But I can tell you Representative Humphreys had been working on this bill for a couple of years before that situation happened. That situation would have been affected by this had it been in place.
Any other discussion? Representative Concanon.
Yeah, and further discussion, I think that just, for full transparency, we passed this out. There were a lot of concerns about it. So it was sent back to committee and it was amended then and was passed back out. We received a letter from, that was signed by several judges and attorneys that work in this field that have concerns with introducing any type of an appeals process into foster care. I recognize their concerns and I think that there are a lot of people who work in the field of child welfare that feel strongly that we shouldn't do this. Um, and honestly, I go back and forth on it all the time. I do understand the concerns of bringing this to the committee and them not having heard it. So I just wanted to share with you some of the back and forth that's gone on with the bill. Thank you, Madam Chair.
Committee, I will explain a little bit more also that if you sit on any sort of child welfare committee, or even if you don't, I assume that you all have gotten emails from people who were foster parents, particularly, or maybe that have had some issue with the child welfare system. And, you know, the most egregious one I can think of was a family in Sabetha that had a child for 4 years. And they had an adoptive situation where they were going to adopt the child. And then they found at the last minute an older brother who was 19 that was the adoptive choice instead. And so they just that day when they thought they were going to do the adoption, the 4-year-old was taken with the older brother, and they had no recourse. It was just a done deal. They had no, and so this bill is in response. That's the most egregious one I can tell you about, but there are many, many that we have heard of. And so this is just trying to encourage the system to take into consideration attachment. And really the crux of the bill is on page 3, line 25. If a child has been in the custody of the secretary for 1 year or more, the secretary shall give preference to a placement that maintains the child's close and healthy attachments. The secretary shall consider the foster parent as a prospective adoptive parent. So they're considered as a prospective adoptive parent. And when the child has lived more than half their life with the foster parent, or the child has lived more than 2 years with the foster parent, or the secretary determines it's in the best interest of the child. Everything is always done in the best interest of the child. And then the next paragraph, that the foster parent, if they're not selected, they may request direct placement of the child. And direct placement is a motion that can be made now, and then may appeal that decision to the Court of Appeals. So it's giving that parent some recourse, and it's not insisting that DCF or any of the contractors choose the foster parent, but it's asking them to take it into consideration. That is really the crux of the bill. And again, I feel like we found out just recently that many states, other states, have an appeals process, which kind of encouraged me to go ahead and do this, because other states do have an appeal process in their child welfare. So I submit that to you, and I think there's a little bit more conversation, Representative Heiberger.
Thank you, Madam Chair. And with all due respect, I know it's frustrating to have a bill that you've been working on for years and have it not passed. There are things I've been working on for 10 years and I'm never going to get them passed. I can't in good conscience, I would be in dereliction of my duty as a legislator to vote to approve this amendment in this bill, because I don't have enough information. I don't. So that's where I am.
Representative Osmond.
A question for the chair, if I might. I realize that you were not the Speaker of the House, but are you able to speak as to why this bill did not come above the line? Why is it not available through the normal process for us to debate this on the House floor?
Yes, I would say it's okay. So again, it did go above the line last year. And you all in your calendar or your agenda, you heard about the bill, and then it was skipped over the day that it was above the line, twice actually, because it was sent back to committee, and then it was above the line again. So we've heard it. We've heard it. And then this year it's been below the line because I was waiting for some more information and again, I want to be perfectly upfront. If I had pressed it, it probably would have gone above the line. And the reason I didn't was because I was waiting to hear about some information from other states, get people together in Wichita. I had asked people to get together. In fact, a couple of attorneys that you've actually heard from in this committee, different testimony, and it just I never was able to pull it all together. So I will take it upon myself. I could have pressed the majority leader to put it above the line, and it just didn't. And now we're at the end of the session. So that's full disclosure. Yeah. Representative Vaughn.
Thank you, Madam Chair. I guess, I was able to get a hold of some of the testimony from the bill when it was heard. And, I am worried. It doesn't seem like there's a general consensus about moving this bill forward, or that there are things that a lot of people agree are important about this bill, but that there's not general consensus, especially around the appeals process, that that's the right way to move forward. And so, especially since we haven't heard the bill in this committee, and I know conceptual amendments aren't allowed in this committee, and we would just be moving this bill forward as is, even though I think there are things that possibly need to be discussed in greater detail and potentially changed. I'm also worried about this bill moving forward today. Will not be able to support the motion. Thank you.
Any other discussion? Representative Owens.
Thank you, Madam Chair. I know this has been something that the chairman of this committee has worked on. The chairman of our Child Welfare and Foster Care Committee. And I also understand this is not a conventional process, but this is also will have the ability to be debated on the House floor if it moves forward. There will be opportunity for amendments. There will be opportunities in conference to work on this bill. And so I'm going to support my chair. I'm going to support both of my chairs. Thank you.
Representative Titus.
Thank you, Madam Chair. I'd just like to echo Representative Owen's comments there. It would maybe be different if we didn't have the Child Welfare Chair also sitting in this committee, but I respect their work greatly. And if we can move the process forward and still allow for several opportunities to debate, I'd be willing to support this.
Representative Heiberger.
For one more bite of the apple, but in response to previous legislators' concern statements, the chair of the Child Welfare Committee has expressed that she's not sure whether she supports the amendment or not. So I guess that makes me think that with as little as information I have, that I certainly can't.
Should say what you said. It's fine. Go ahead.
Well, I support all of the work that Representative Chair Humphreys has done on this. I honestly, I asked, we had the Casey Foundation people here for the Oversight Committee on last Friday. And I asked them specifically if an appeals process slows down. Well, I've asked other states if they have an appeals process, and many other states do. And the big concern is that it's going to slow down the process, that there needs to be an end to a child welfare case at some point. And, the appeals drag it out. The answer that I got was that no, it didn't significantly slow down the process in other states, as long as, you put timelines in there. I acknowledge that. I acknowledge the concerns that I've heard from two Supreme Court justices that are worried about this, and other judges. And I don't know. I'm in a terrible position as far as saying whether I support it, but I'm concerned about it. So, and I acknowledge that it's difficult to vote on something that's outside of, that's been worked on outside of this committee by another committee. But I'm also supportive of the chair. So take that all for what it's worth. Probably nothing.
Representative Neely.
Well, the where I'm looking at it from, in that I have the trust. I trust my chair, and I also trust your decision, also, Madam Chair. But I will tell you that the devastation I saw in the case that was dealing with mine, we need to do something. And if it is need to be debated on the floor, then let's debate it on the floor. Let's fix it. But let's not put these children and these families through that again.
Any other discussion? Representative Bourgeon.
Thank you, Madam Chair. I would echo what some of my other members have said about the process, but it sounds like it is an important issue, and so I will be voting to support my chair, and there will be further time and opportunities to make necessary changes if they're necessary as we work this bill through the process. So that's where I'm at.
Representative Lewis.
Thank you, Madam Chair. I happen to also be on the Child Welfare Committee, and I've heard this bill. I support this, and I'll be voting in favor of the amendment.
Do we have any other representative on?
Thank you, Madam Chair. I guess I figure it doesn't hurt to ask if it would be the committee's the chair's wishes, or she would allow for us to consider a conceptual amendment if the appeals process is, in fact, the part of this bill that there is not consensus on, that we consider removing section, I believe it's lines 36 through 39 on page 3, which I believe is the provision that puts in the appeal process.
Can I ask you to repeat exactly what it is that you're asking about?
Sorry. So my conceptual amendment would be to remove the appeals process from the bill, because that seems to be what is there's the least consensus around. So and this is my very novice understanding, because I'm just getting the bill, but that way placements, they'd still have to consider the best interest of the child in the placements, but right now it wouldn't include the appeals process. Given additional consideration, you know, I think that that's something that could be added in at a later time, but if that's what is causing the least consensus at the moment, perhaps that could be removed, and then the rest of the bill could be moved forward. And so that, if a conceptual amendment would be allowed, that would be my amendment.
I don't know how to ask this, but would you be in favor of the amendment if your conceptual amendment was passed? I mean,
no, I appreciate the chair's directness. I think I will probably be voting no on process, but I think that, you know, just again, based on my quick research, that is the greatest concern about this bill. And so if I were to be able to support this bill in the future, even though I cannot support it right now and due to process, that I think that is the provision that seems to stick out to me as not having consensus at the moment. So
thank you. And I appreciate your honesty about that too. Okay, any other representative Mon?
Thank you, Madam Chair. If I could direct a question to Representative Concanon. I guess I'm trying to figure out how much of a problem that the appellate process would be, because it would be, I'm trying to think through who would be the appellee. It would either be some family member who hadn't really been forming a bond with the child, or if the district court gave custody to a family member, it would be the foster care family who had formed a bond. And so I guess I'm trying to figure out how big of a problem this would be. Because I would think that family members who hadn't formed a bond with the child probably aren't going to appeal this. And there's no prohibition upon having continued contact and developing relations with the rest of the family. Um, and so I'm just trying to get my head around this. I'm generally in favor of this amendment. I just wanted to kind of, for those of you who've studied a little more, um, could you respond?
Representative Kincannon.
Thank you, Madam Chair. So the Pele would be a foster family. I mean, that's the guardrails that we put in place. You know, bio parents, those rights have already been severed. We're looking for permanency, and it's when there is the ruling that goes against the foster family. But you know, that's where my concern has been too, is how big a problem would the appeal process be, or is it just that we have judges who like the way that they do things now, that think things are going just fine, and they don't want to change? I mean, this is a decision that we're being asked to make, and like I said, I've kind of gone back and forth, but I've been supportive of this and through the whole process that it's gone through, because I think that it's important enough to keep looking at it. So, I mean, I'll support the chair in this with her motion to amend the Senate Bill 232.
Representative Heiberger, did you have something?
Yeah, I'm sorry for one more remark, but in response to some of the comments of my colleagues here, you know, I trust the chair too, but if trusting the chair was a sufficient justification for passing a bill, why do we have any of our processes, and why are the rest of us here? So.
Okay, any other discussion, committee? Representative Osborne.
Just one more quick thing. So it may be correct that we will have the opportunity to debate this on the House floor, but we might not. This might be something that will go straight through as a conferenceable bill and then get hatched out on an up or down vote in committee. And if that's the case, we will have not heard it in Judiciary. We will not heard it on the House floor, and we will not be debating it anywhere but amongst 6 different people to determine on an up or down vote with no amendments whether this is something that that we should pass into law. Beyond that, there's just the general issue of, look, we the process is there for a reason. Again, I still don't know much about the bill itself. I realize there's been a lot of information that's been presented, but we haven't heard any testimony. We haven't had the chance to question that testimony. So all of it is coming from secondhand information, which is not the way that I wish to pass a bill. So again, this bill might be very good. I can't make that determination today. And I'm afraid that if we go through this process, no one will be able to make that determination. It will just be an up or down vote 2 weeks from now. Thank you.
Committee, are there any other questions? Okay, just 1 second. Okay, any other, sorry, I just had to do a little process. Just, yes, another process question. Okay, so, all right, committee, I'll close on my amendment. I understand this is unconventional and I understand your concerns. I have been committed to amending this 2299 all along to try to address some of the questions like that Representative Vaughn had. Either taking out the appeal process, putting a time limit on the appeals process, figuring out who, if one group or both sides need to be part of the appeals process, I'm 100% willing to adjust as we needed, adjust as we would need to, either on the House floor or in conference committee. So, committee, I'm going to leave it to your will. I think this bill has been hashed out. I think there's a great need to do something along these lines. And so, but I'm going to leave it to your will. And with that, I move my amendment. All those in favor of amending Senate Bill 232, as we have been discussing, say aye. Aye. Opposed, no. No. The ayes have it, I believe. Okay, that's fine. All those in favor, please raise your hand. I'm counting 9. All those opposed, raise your hand. 5. So the amendment passes. Okay, Representative Curtis, no vote, and Representative Heiberger. Okay, so we have now amended Senate Bill 232. And do we have a motion about Senate Bill 232? Representative Goddard.
Thank you, Madam Chair. I move that we pass Senate Bill 232 as amended out of committee, favorable for passage.
Is there a second? A substitute bill. Yeah. Second by Representative Mon. Any discussion? Seeing no discussion, Representative, you may close.
Madam Chair, I close.
Thank you. Committee, all those in favor of passing substitute for Senate Bill 232 as amended favorably for passage, say aye. Aye. Opposed, no. The ayes have it. We have passed Senate Bill 232 and no votes by Representative Carmichael and Heiberger and Curtis. Okay. Okay, thank you, committee. We have two more things. I did get that most controversial one out of the way. Okay, we are now going to look at Senate Bill 190, which did not pass out of committee yesterday. And I have an amendment for that bill, and it is to take House Bill 2780. We're going to be looking at House Bill 2780 and putting the contents of 2780 into Senate Bill 190. Natalie, after we pass that out, if you could give us a little bit of an update on 2780. It's the yeah, just so people remember what it is that we're doing here. And committee, I just want to remind you the reason to put something into the Senate bill from House Bill 2780 is to put it into a Senate bill is to expedite the passage of the bill. And so, yeah, Natalie will give us a little, or is it 2780 is in here, is on this, in this also that you gave us?
Madam
is attached.
Chair,
Mm-hmm.
So yeah, the balloon that we just passed out, because you are gonna be talking about Senate Bill 190, possibly putting the contents of 2780 into that bill. You'll see House Bill 2780 introduced in the balloon. And 2780 requires people who file lawsuits for wrongful conviction compensation to prove additional information It changes the compensation rates to daily rates instead of yearly rates, and it limits housing assistance offered to those people once they have been awarded a judgment.
Okay, committee, any questions on the amendment? I mean, I'll move the amendment to put the contents of House Bill 2780 into House Bill 190. Do I have a second? Representative Lewis. Any discussion on that? Representative Carmichael.
Thank you, Madam Chair. We listened to testimony on this bill quite some time ago, 2780 I'm referring to. And I have to be honest with you, I cannot remember all of the testimony. But my recollection is that there were somewhere in the area of either 25 cases that have been brought under this outstanding legislation that we passed several years ago. Of those, approximately 12, I think, have been dismissed. Compensation has been awarded, and I think it was something like 8, or maybe, I can't remember exactly the numbers. And it seems like 8 sticks in my mind, or maybe 12 are still pending. And I know those numbers don't add up. But the bottom line is this bill has worked exactly as it was intended. The unmeritorious claims have been dismissed in short order. The meritorious claims have been paid. And even in some of the largest payouts, the state has retained its subrogation interest in the civil lawsuits that are currently pending against the people who distorted the justice system to obtain the wrongful conviction. The Attorney General's office provided us with absolutely nothing that was wrong with this case. The one argument that they continued to repeat was, well, people who are not actually innocent are filing these claims. And these claims are being dismissed because actual innocence is an absolute requirement in order to qualify for compensation. I have absolutely no idea what the smart lawyers at the Attorney General's office have to do with their time other than to sit around there and rewrite legislation that is accomplishing the worthwhile purpose that was accomplished by this committee so many years ago. Then we have this provision that is supposed to somehow benefit lawyers who are bringing these claims. We had great discussion in this committee at the time the legislation was first passed as to what to do about attorney's fees. We realized that if we made this a type of case that lawyers could handle on a contingency fee basis, that we would not be providing full compensation to the wrongly incarcerated people. And by the way, wrongly incarcerated people are not criminals. They haven't committed a crime. They are victims. Oftentimes, they are victims of lies told by criminals. These people are innocent. But when we analyzed that situation in this committee at some length, what we concluded was it would be better to, quite frankly, have the state pay attorney's fees based presumably upon an hourly rate out of state funds, rather than to only partially compensate innocent citizens who have been wrongfully placed in the penitentiary. I can't think of anything more horrible than to be an innocent man and to be placed in the penitentiary away from friends and family for a crime that I did not commit. But what the attorney, and what we did was, we said the run-of-the-mill cases, $25,000 or less, whatever the hourly rate, and the judge is an expert on what reasonable attorney's fees are, whatever the judge thought was right, or excuse me, the fee up to $25,000. That's what the judge would typically approve, but only in those aggravated or unusual cases where there had been unjustified recalcitrance, for example, by the Attorney General's office in paying a just claim. We wanted to make sure that in those very rare cases that the lawyer could expend the time necessary to successfully prosecute the case. In other words, the state of Kansas, who has the deepest pockets in Kansas, could not just wear out the wrongly accused person and their lawyer by litigating the case to death. And I think we heard that's been working fine. But now, for some reason, the Attorney General comes in and says we need to have an absolute limitation of $100,000 on attorney's fees, and then portrays that as something good for the lawyers who represent these citizens who have been deprived of their liberty. No, that's something bad for the lawyer. The law right now is $25,000 or less, unless the judge finds exceptional circumstances, and then it's whatever the lawyer earned. We are told by the Attorney General's office that there's a plethora, presumably, of jailhouse lawyers who don't understand that when they get a bad lawyer, even if they're actually guilty, that they're not compensated under this statute. And that's the way the law is written right now. Okay. Whether your lawyer's good or bad or otherwise, or whether somebody just lied, or whether it was a messed up DNA test, or whatever it was that got you in jail, no matter what it was, you're not entitled to compensation just because your lawyer was no good. You have to be actually innocent. This turns that rule on its head. It seems to say the amendment that the Attorney General gives us seems to say that even if you're actually innocent, but your lawyer didn't do a good enough job of ferreting out the lying witnesses that the prosecution may have intentionally or unintentionally presented, that you receive no compensation. I would venture to guess that in a very large percentage of cases where people are wrongfully convicted, there is also a concomitant ineffective assistance of counsel claim. What the Attorney General proposes is people who are actually innocent, who've been convicted by a jury based upon fraudulent evidence, but who also had a lousy lawyer, they're just not entitled to compensation. And by the way, in these types of cases, that ineffective lawyer is almost always a lawyer that is either an employee of the state of Kansas through the Board of Indigent Defense Services, or it is a contract employee of the Board of Indigent Defense Services. You know, if this were a world where people who are wrongfully accused hire their own private lawyer in these types of cases, that would be one thing, but that's not the practical reality, because unless you're wealthy, if you're charged with a crime, by the time you get to a jury trial, whatever assets you had will be gone. And I've seen it time after time after time. If the Attorney General's office had given us good reason to have a trailer bill to fix something that needed to be fixed, I'd support it. I want this to work. But right now, there's just no problem that the Attorney General's office has shown us. Instead, it's an attempt to undo the good, hard work that so many of us, from the chair to the youngest member of this committee, were so proud of. This is an attempt by a new Attorney General based upon the flimsiest of reasons to vitiate the good work of this committee and this legislature. And I absolutely oppose this amendment.
Representative Heiberger.
Thank you, Madam Chair. In addition to the concerns raised by my colleague to my right, or to my left, depending on how you look at it, I have concerns about section capital D on top of page 2. There's a new element added that a claimant has to prove to receive compensation. It requires the claimant to prove that the claimant's own conduct did not serve as the basis, did not contribute to cause or bring about the conviction. It requires the claimant to prove a negative, which is often difficult or impossible. I think it imposes an additional unnecessary hurdle for compensation. And for all those reasons, I'll be voting no.
Committee, are there other Representative Mon?
Thank you, Madam Chair. First of all, I would like to just point out that, because somebody is not guilty doesn't mean that they were innocent. And so, having this requirement that before somebody receives benefits from the states, that they actually prove actual innocence is an important thing. It's not simply the fact that, okay, you were found not guilty. That doesn't mean you were innocent. That just means there wasn't insufficient evidence presented to find you not guilty beyond a reasonable doubt. While I appreciate the comments of my friend from Wichita, I don't know if this would be appropriate, but I would offer a conceptual amendment to section 1B2. A person shall not bring an action pursuant to this section if such person's conviction was reversed or vacated. I would add solely based on ineffective assistance of counsel into that section, if that would be acceptable to the committee and to the chair.
So if I may, Representative Mon, it's my full intention to bring an amendment to you all after we place this bill into Senate Bill 190 to bring amendments to address some of the issues of Representative Carmichael also, that when I first saw this bill, that was my concern, was that it seemed like if you had ineffective counsel, assistance of counsel, that then that would bar you from being able to then prove your innocence. And I was concerned from the very beginning. And I just, again, I'm pretty much full disclosure about everything. I couldn't support that bill if that was the case and that was how this was going to operate. But for now, we're trying to put this bill into Senate Bill 190, and then I will offer a follow-up amendment. Just so you know, that's what the plan is.
Fair enough. Thank you.
There's any other discussion about the insertion of House Bill 2780 into Senate Bill 190? Representative Carmichael.
I do appreciate first the words of my colleague from Colwich as well as the words of the chair, but not knowing what part of this bad idea is going to be fixed, I can't vote to start down the road or the process without knowing whether or not it is going to be fixed or how it's going to be fixed. So I'm going to remain a no vote on the amendment.
Okay, thank you. Anyone else? Questions or comments on this amendment? Okay, I'll close on the amendment and ask you to vote to insert the contents of House Bill 2780 into Senate Bill 190. All those in favor of the amendment, say aye. Aye. Opposed, no. The ayes have it. I'm sorry, yes, of course. No vote for Carmichael, Representative Carmichael, and Representative Heiberger. Okay, now, are there other amendments? And yes, there are. At this point, Natalie, we would be amending Senate Bill 190. Okay, just want to get my lingo straight. Since we've all kind of looked at this, I'll just go ahead and explain. Actually, the amendment that I'm offering before I make my motion, it just completely strikes that section B2. So that section is not in there whatsoever. And then it also makes a little bit of changes to the housing. We had talked about that during committee, that there was some confusion when it said anyway, the monthly payments for the housing was changed just a little bit. And so that it striked the definition of housing assistance at the end and instead moved it up to page 3, the middle of page 3. It does the same thing. It just made it flow a little bit better. So with that, I will move my amendment to Senate Bill 190. We have a second, Representative Mont, seconds. We have discussion on the amendment. Representative Lewis.
Thank you, Madam Chair. Yes, I think the amendment makes sense for the reasons you gave. It could be, for instance, that someone gets the conviction vacated on grounds of ineffective assistance, but the court, because it's already vacated on that basis, need not and does not go on to determine whether there's actual innocence. And so I think we don't want to preclude someone who has a conviction vacated on grounds of ineffective assistance to be precluded from pursuing their rights under this bill to restitution if they truly are innocent.
Any other discussion on the amendment? Okay, with that, I'll close on the amendment. All those in favor of amending Senate Bill 190 with the amendment that is in front of you, say aye.
Aye.
Opposed, no. Okay, so this bill is amended again. So that's 2 amendments for Senate Bill 190. Now, do we have a motion on the bill itself? Or excuse me, are there other amendments? Okay, yep, go ahead.
Sorry, Madam Chair. This is on the fly, but in regards to Carmichael's comments, I would have a conceptual amendment if it would be allowed by the chair and the committee regarding the attorney fees section, that the cap be raised as they have requested $200,000, but that the ability for good cause shown exception remain. So right now it raises the cap from 25,000 to 100,000, but then removes the good cause shown exemption. So then I would just be asking to keep the cap that they're recommending, but then in the situation, as the representative from Wichita had mentioned, that it was deemed that reasonable attorney fees actually exceeded that amount, that good cause could be brought.
I'll second, Madam Chair.
I'm still considering the conceptual amendment situation. I want to be consistent. I'm going to say I've made a rule about conceptual amendments. I've tried to adjust and do what I can. I just feel like I've got to be consistent about it. And even so, I appreciate that. And I don't know that that's an unfriendly amendment that we could have on the floor. I don't really have an opinion about that amendment particularly, but I just feel like I'm going to need to be consistent about the conceptual amendments.
Thank you, Madam Chair. Yeah, I think I guess my comment would just be, I think if I had known that we were working this bill and it's possible I would have had that amendment ready. So that would be my comment. Thank you.
Representative Carmichael.
It's an unfortunate device when you don't know that a bill's going to be called up, so you can't have amendments drawn. And then you're told No, can't have a conceptual amendment either. It denies those of us who aren't in the loop the opportunity to amend the legislation. That's wrong.
Are there any other comments? Representative Heiberger.
I'm going to speak up in defense of the chair. I mean, we were told yesterday that 2780 could possibly be inserted in 265 or 379. That's what my notes.
I will have to eat my words that I do have a note here that at the very end it says HB 2780. So that there may well have been notice.
Thank you. Okay, any other discussion, committee? Okay, then I will close on the amendment. All those in favor say aye. Opposed, no. Okay, we have amended Senate Bill 1, or we have twice. We have now amended Senate Bill 190 twice. Okay, now we're on the bill. Okay, do we have a motion on the bill itself?
Madam Chair, I'll move that we pass Senate Bill 190 favorably out of committee as amended.
Do we have a second on that? Representative Lewis, second. Any discussion on that? Seeing none, then we will, Representative, you may close.
Close and move my motion. Thank you.
All those in favor of passing Senate Bill 190 as amended favorably for passage, say aye. Opposed, no. The ayes have it, I believe. Senate Bill 190. Representative Carmichael is a no. Representative Heiberger is a no. A substitute. Thank you. Thank you. Okay, committee. We actually have two things left. This one is House Bill 2805. If you remember that one, it's the okay. Sorry, going back. We're actually going to work now Senate Bill 349, which was referred to our committee. And I have an amendment on Senate Bill 349. And what the amendment does, it inserts the contents of House Bill 2805. House Bill 2805 is a bill you heard that has to do with the exceptions to yes.
Madam Chair, so what this amendment would propose to do would be to put the contents of 2805, that's the open records bill. You guys amended that bill and you passed it out of committee yesterday. And it would propose to put the contents as you amended it yesterday into Senate Bill 349. And I guess I should just clarify it, remove the underlying contents of Senate Bill 349.
I'll make the motion to amend and Representative Owens will second. And of course, just to explain the amendment a little bit, the reason is because if it was a House bill and we pass it out today, and even if we pass it out next week across the House floor, then it wouldn't make it to the Senate. And this is one of those bills that must be passed every year by the legislature. So that is the reason that we're doing that maneuver and we passed this bill yesterday. Representative Heiberger.
Madam Chair, I understand the reasons, but I can't stand by for another, what I think is a violation of our process. The way I understand, the way I read Mason's, even a gut and go has to be germane. I challenge the germaneness of the bill, of the amendment.
So it is my understanding that in committee, that germaneness is not, germaneness is not germane to the discussion. My vice chair just said, that's my understanding, and I've checked that out. That that germaneness is not an issue in committee as the same way it is on the House floor. So okay, thank you. Is there a discussion? Any other discussion?
Was that a ruling on my motion?
I'm sorry, what did you say?
Was that a ruling on my motion?
Yes, it is.
Okay.
Senate Bill 349, Representative Carmichael.
Would it be appropriate to inquire what was the fate of Senate Bill 349? I mean, this is a very important bill to my city in Wichita to extend the Heartland Flyer. I have no idea why they sent it here, whether it's been taken care of somewhere else by appropriation, or whether this is just killing a bill that is vital to South Central Kansas.
That's an excellent question. It came to us from the chairman of the Transportation Committee, and he said that he won't be using it. That he didn't explain to me if this language is in a different bill, but he said absolutely it's nothing that he intends to work in his Transportation Committee.
I had heard such a rumor, not with respect to it being sent to our committee, but I heard a rumor that perhaps my friend, the chair of transportation, didn't want to work this bill. Anybody from South Central Kansas had better think long and hard. Better think long and hard about doing a gut and go on this bill. This bill is advocated by the city of Wichita. It's advocated by Sedgwick County. It's advocated, as I recall, by the Chamber of Commerce. It's advocated by the Greater Wichita Foundation. It's advocated by anybody and everybody in South Central Kansas. If you think you need to mess around and do a gut and go on something, you sure don't do a gut and go on something like the Heartland Flyer. This is important to our constituents in Wichita. And it's important to constituents. It's important to constituents all the way from Oklahoma City to Chicago, because the missing link in interstate rail transportation between Fort Worth and Houston and Chicago is a stretch between Oklahoma City and Wichita. So I don't know why anybody from anywhere in South Central or Central Kansas, or for that matter, Lawrence or Topeka or Kansas City, would want to see the Heartland Flyer thrown in the proverbial legislative trash can so that we can find a place for an open records renewal that we've already passed out of the committee and awaits a hearing on the floor. The Senate is well aware that we have to pass the Open Records extension, because if we don't, the Open Records Act expires for those various new enactments that we have. There is something known as Rule 4K. Even if they don't get around to it now, you all can remember the hours and hours and hours we spend in veto session as we suspend the rules to hear bills pursuant to Rule 4K. We're not going to lose the open records bill because we haven't stuck it in a Senate bill. I'll give the Senate credit for being smarter than that. There is some language in the bill that I would like to address in the amendment that's been provided to me, if you'll bear with me. At page 8, there is a balloon in sub 2 that says something will not be a public record and shall not be subject to Kansas Open Records Act. I'm not sure what that balloon is about. Could perhaps the reviser help me understand?
Sure. Thank you, Madam Chairman, Representative Carmichael. That was the technical balloon that you adopted on House Bill 2805 yesterday from our office.
Okay. And then just so that I'm clear, at page 10, the balloon there, I believe, is incorporating what we passed as the Titus Amendment. Yes. Well, actually, in its final form, I think it was Representative Landwehr's amendment. I had the privilege of seconding that amendment, but I think that's what the other balloon is. Is that correct?
Yes, that is correct.
Yeah. Well, we went from never released, I think, to 5 years to 2 years, if I recollect. I think that's maybe correct. But I really hope that this committee will think long and hard before you put the, I better not say a word because I don't know what it means in a foreign language. I've been known to say cuss words in foreign language, not knowing what they were. But I think it's a really bad idea for the House Judiciary Committee to put the stake of death into the Heartland Flyer. Good Lord. Thank you. Apologize, God. Forgive me. Thank you.
Representative Landwehr, or do you have a question or a comment online? Is she there? Oh, Representative, you might be muted. Okay, still muted. Okay, all right. Okay, Representative Landwehr, if you come back or if you can hear us, if you have a question, we'll call on you again. Representative Vaughn.
Thank you, Madam Chair. In regards to the representative from Wichita's comments, and also as someone who is strongly supportive of the Heartland Flyer extension and the both the passenger and economic potential that it has for our state, I would actually make a substitute motion, and that instead of amending the bill, that we pass out Senate Bill 349 favorably for passage.
We have a substitute motion by Representative Vaughn and seconded by Representative Carmichael. I would like to call on our legislative researcher, please, for some comment. Thank you.
Thank you, Madam Chair.
Mulholland.
Thank you, Madam Chair. Jordan Mulholland, Legislative Research. I had searched for some of the language from that bill, from Senate Bill 349, and we've had some other staff looking into it, but it appears that some similar language is within the Senate's version of the budget that's currently been referred to HAP. I can't say whether it's exactly because I'm not familiar with it, but it does appear that there's some similar language that's been in that Senate version of the budget bill.
Okay, thank you. Representative Owens.
Well, I believe, first of all, we have a substitute motion. So do we have a second on that?
We do have a second.
Okay,
Representative Carmichael.
I wasn't 100% sure.
Mhm.
Okay, so it kind of goes back to that exact same thing. That is in the budget. It is being debated through the budget process. And so by using this as a shell, even if it wasn't in the budget process, it is certainly still, because it is past one body, conferenceable and could be put in another shell another day. So this is by no means the stake of death for the contents of Senate Bill 349. Just wanted to clarify that. So I'll be opposed to the substitute motion.
Representative Vaughn, you wanted to say something? Yeah.
Thank you, Madam Chair. Just to clarify the points brought by KLRD, and if members of the Appropriations Committee have additional information from my knowledge of 349, it's not just the appropriation of the $5 million, but it has policy tied to it in terms of allowing this to move forward. So, I mean, I don't think, I mean, is that policy also part of that budget line item in the form of a proviso? I just want to make sure that all the contents of this bill are moving forward, and I guess that would be my question. Thank you.
Jordan.
Thank you, Madam Chair. If it'd be helpful, I can read the language that's in Senate Senate Bill 514 for the committee. Would that be helpful to
Sure,
read that?
that'd be great. Thank you.
So it does look like it is a proviso language. Like I said, I am not involved in that area policy, so I can't make a judgment call on whether or not this has everything in it, but I thought it might be helpful to at least read it for you all. So it says, provided that notwithstanding the provisions of KSA 75-5089 and amendments thereto, or any other statute, expenditures may be made by the above agency from the Passenger Rail Service Revolving Fund during the fiscal year ending June 30th, 2025, to make loans or grants for the cost of qualifying projects and operating support for Amtrak or any other common rail carrier approved by the Federal Railroad Administration for operation of an intercity passenger rail service program to connect Kansas by rail to other member states of the Midwest Interstate Passenger Rail Commission, the Midwest Regional Rail System, the National Passenger Rail Network, and any other passenger rail service operations serving Kansas. Paragraph B says expenditures may be made by the above agency for the fiscal year ending June 30th, 2025 from the State Highway Fund for the following specified purposes, provided that expenditures from the State Highway Fund for fiscal year 2025, other than refunds authorized by the law for the following specified purposes, shall not exceed the limitations prescribed therefore as follows. And then it's got some additional language about the agency operations and a fund number and an amount there.
Okay, thank you. Representative Vaughn.
Thank you, Madam Chair. Thank you for that clarification. I think that is some of the bill language, but of course, proviso is only good for 1 year. And the bill does request a $5 million transfer each fiscal year in order to, for the interest to accrue, for that interest to be used in order to pay for the Heartland Flyer. So I would still be in support of my substitute motion. Thank you.
I'm going to go ahead and call on Representative Landwehr, who's had her hand up, and then Representative Heiberger after that. Representative Landwehr, you have a question or discussion? Oh, are you muted? It seems like you're muted is what we're getting that word. She's here. Okay, she has her camera on. Brenda, can you do sign language to tell us what you want to ask? Okay. Okay, so our IT helper is going to unmute you, Brenda. Representative Landwehr. Can you see her mouth moving? Oh, she's talking. Okay. Brenda, nod your head if you can hear me. Yes, she can hear. But I'm so sorry, we can't hear you. I think Representative Owens will give you a call and you can maybe ask your questions through him. In the meantime, I'll call on Representative Heiberger.
Thank you, Madam Chair. Representative Vaughn said most of what I was going to say, but I've been working on this issue for almost 20 years since I was on the City Commission in Lawrence, Kansas, and I was really excited to see some potential progress on this today. There's absolutely no way I can vote to gut a bill that would put this Heartland Flyer in law.
Representative Owens.
The exact words were from Representative Landwehr. I'm just going to come up. This is crazy. Beep.
Okay.
So she's on her way.
All right. Any other discussion? Representative Carmichael.
Thank you, Madam Chair. I do appreciate Legislative Research's work on short notice, like all of us are on short notice on this idea. But I may not have heard you say what was the amount of the appropriation under what does appear to be language of proviso.
Yes, Jordan.
Thank you, Madam Chair. Jordan Milholland, Legislative Research. I did pull up the budget explainer and it does have a bullet on there, so I can tell you. It says under the major additions to the FY 2025 budget, it includes 5.0 million and transfer the same amount from the State Highway Fund to the Passenger Rail Service Revolving Fund to support an intercity rail service such as the Amtrak Heartland Flyer.
Sounds like it's a one-time $5 million appropriation. I don't know that you could give an opinion on that, and I stay away from the budget committee, but I think that's what it means. And that's not sufficient. We are in a national competition for this rail service. Amtrak is not going to fund everybody who wants to expand their rail service. In that competition, it is important for us to be able to show not only that we have the funds for today, but we will continue to have the funds. That's why Senate Bill 349 establishes a revolving fund and a continuing allocation of $5 million every year for the Heartland Flyer. If I'm sitting at Amtrak and I'm evaluating proposals, and Arkansas has a proposal for the line from Tulsa to Little Rock, and they have a continuing funding source for it, then I'm going to be a lot more likely to say that's what I'm going to spend the money on, rather than saying, well, we could send it to Kansas, but the problem is their legislature doesn't have a revolving fund. It has a one-time proviso allocation of $5 million. So you can't go invest hundreds of millions of federal dollars in this project on the hope that the Kansas legislature will keep kicking in $5, because you could be throwing good money after bad. This is not good for South Central Kansas, and Representative Vaughn is right. That's what we ought to be doing with this bill is. We ought to pass it out. We ought to pass it out because it needs to come above the line, and we need the Heartland Flyer extension. And gutting and going on this bill sends a terrible message to Amtrak about this state's commitment to the expansion of the Heartland Flyer and the future of my city of Wichita, Kansas. I cannot vote for this unless we amend it.
Representative Landwehr.
Thank you, Madam Chair. I'm not sure what happened because I had it off mute and it had worked earlier. But anyways, what I was going to state was listen to Representative Bond earlier. Now that I've listened to Representative Carmichael, it is not unusual in the appropriations process for us to take a bill and actually basically put it in as a proviso in the appropriations bill. And I'm going to guess and assume, and we know what assume does, but I think I can bet on this one, that what was put in on the Senate was probably put in by Senator McGinn, who has been the leader, taken the charge on getting this project moving forward into the stage in which it's at. They know that we're in the early beginnings, and the fact that they can have 1 year worth of funding will be sufficient for them to do what it is that they need to do. And then we can come back in next year and work another bill. So it doesn't kill the project. And I can guarantee you Senator McGinn's not going to let it kill the project over there. So there's no reason for us to worry about this bill stopping what's going to go ahead.
Thank you for that information. I'm curious if anyone on the committee is on the Transportation Committee. Representative Neely, do you have any insight into Senate Bill 349?
A little bit, and in that I also was visited by those that are involved with the Heartland Flyer, and I do know that they were looking into some other things involving the federal money, in that Amtrak has to study the previous railroad areas across the nation, and one of the places that we're trying to get our federal legislators is to pressure Amtrak into studying the fact that they need to turn around and reopen this back up for the Heartland Flyer. They have not done that. I do know that they are studying some of the other ones across the United States already. But I do not know, you know, as far as this part of it. They were in there the other day. They were very optimistic about the federal part of it. But as far as where this was going, this bill, you know, there was no indication from my chairman that we were passing this out this year.
Thank you. Thank you. Representative Goddard.
Thank you, Madam Chair. I also serve on the Transportation Committee, and I fully concur with Transportation Vice Chair Neely on his comments.
Thank you. Did I see your hand up? Anyone over there? Oh, sorry. Oh, so sorry. Representative Mon.
It's just, and maybe this question is mainly for the revisers. So if we approve the substitute motion, what would become of House Bill 2805? Would that just simply then be dead, or would we?
Madam Chair, Representative Mon, you all passed out House Bill 2805 yesterday, and so that committee report, got it right here, it'll be turned in tomorrow. So that bill then will just sit below the line. But as Representative Humphreys indicated, you know, it has to make its way over to the Senate and be heard. So I think the intent was just to expedite that, get it straight into conference by putting in a Senate bill.
Okay, so a follow up to that would be if the Senate Transportation Committee has indicated they're not going to move on 349 or working. You know, I mean, I guess we could move it out of here, but then it would have to go back to them, right? Is that how it would work?
Madam Chair, Representative Mon, if you were to pass out, if the substitute motion were to pass and you were to pass out 349 unamended, you know, favorably, then it would just go below the line and potential be brought up for debate next week.
Potentially stay there. I know the speaker's position on this.
So I'll call on Jordan Mulholland.
Thank you, Madam Chair. I've been in communication with our fiscal analyst who represents the Department of Transportation's budget within the process. So I was going to provide some clarity on the proviso within the Senate version of the bill. So what he wrote to me is that it is currently a one-time proviso for FY 2025, and there's not further certainty that the Amtrak support would continue after FY 2025. He also stated that the proviso is not within the House bill, the House Appropriations bill, just to provide that extra background for you.
Okay, thank you. Representative Carmichael.
Thank you, Madam Chair. Representative Landwehr and I do agree that in all likelihood, Senator McGinn probably put that proviso in there. I think many of us in this room have been meeting in this room for the past several years about the Heartland Flyer. And I think there's some inaccuracy perhaps because the federal government has, or Amtrak has approved planning funds for the Heartland Flyer extension. It's not a matter of reopening. Rather, we are already in the process for planning funds. But the big commitment of federal funding, of course, is the actual implementation of the program. And that's where we have to have state funds to match. And that's where a one-time allocation is not the same thing as a statute which provides for continuing funding of the state's share. And that's why it's important we have it in legislation and not in a proviso. I don't think it's a secret to any of us that my friend Senator McGinn has announced her intention to retire from the legislature. She has been the strongest advocate for the Heartland Flyer in this legislature, almost as perhaps more strong an advocate than former council member and Commissioner Pete Meitzner has been over the years. Now, we don't know whether or not Senator McGinn's successor does or doesn't have any. We don't know who that's going to be. We know who's filed, and we don't know whether that person has a commitment to continuing funding of the Heartland Flyer or not. But we know that here today, we can express our continuing commitment to the funding of the Heartland Flyer by recommending this bill favorably as the Vaughn Amendment provides. And I think that'd just be a real good idea if someone wants to represent South Central Kansas. Thank you.
Do we have any other discussion on the, okay, you want to close or do, okay, so I'm going to make a quick comment just on the substitute motion. There is no way the Heartland Flyer is disappearing at this point. I mean, just this week, I had lobbyists in my office. You probably did too. There are plans to continue on. And so I don't think, because the Senate didn't work, Senate Bill 349, I don't think it's an indication that it's not going anywhere. Of course, we don't know all the details, and we know it isn't a proviso in Senate Ways and Means at the moment. But I do find it a little, I mean, I'm just a little surprised that we might be willing to pass out a bill in this committee that we haven't heard, that that the chairman of the committee, now we do have the vice chairman, well, but we don't have the chairman of the committee. Actually, we don't have anyone on the committee because it's a Senate bill. And so I'm just making that point. So Representative, you may close.
Well, I think I'm trying to play by the rules that have already been established in this committee in terms of working bills that we haven't heard. So, but I think just my kind of final wrap up comments based on everyone's feedback on this is 349 did actually pass out of the Senate this year. So 349 passed the Senate 34-6. So now they have passed it on to us so that we can take action on this bill. And by gutting and going this bill, it would be killing it in the process this year. So I think it's important to move it forward. In regards to some of the other comments that have been made, we have already passed out 2805. That's moving forward in the process. That's been done. I think we have the opportunity here to take action on an additional bill that's really important to the future of our entire state. The proviso that's in place, I mean, that's only good for 1 year. I think it's important for the federal dollars that are coming in for them to know that this is an ongoing commitment for the Department of Transportation to have the ongoing authority to make these transfers. And it's my understanding with the way the funding model would work, it is not the $5 million itself that would be going to support this program. It is the interest that will be accrued from investing the $5 million annually. And then that interest is what will be used to fund the project so that the $5 million itself remains in the state of Kansas. So that's why I think this policy is really important. It's not just a line item. It's not just a one-time proviso or investment. I think that was a last-ditch effort in order to ensure that it moves forward this year, regardless of what the House does. I think the House should take action on this bill. And therefore, I close on my substitute motion to pass out Senate Bill 349 favorably for passage.
Committee, you've heard the substitute motion. All those in favor say aye. Aye. Opposed, no. No. Okay, all those in favor of the substitute motion to pass out Senate Bill 349, raise your hand, please. Okay, I count 5. All those opposed, raise your hand, please. That's fine. So the motion fails. Substitute motion fails. So we are back on the yes for Representative Heiberger. Representative Carmichael, would you like to be recorded? Yes. And Representative Curtis, Representative Osmond, and Representative Vaughn would all like to be recorded as yes. Okay, committee, we are back on the original motion, which is to put the contents again of House Bill 2805 as amended into Senate Bill 349. Is there any discussion on that? Representative Osmond.
Thank you, Madam Chair. I have a question for the reviser. Are there any other bills that are Senate bills that Judiciary controls right now that are not otherwise occupied?
Madam Chair, Representative Osmond, I'm trying to understand your question. You want to know if the Senate has any Senate bills that they're...
Judiciary has any Senate bills if our House Judiciary has any Senate bills that we have,
If our committee.
if our committee
Yeah.
has a Senate bill, I'm looking at this list. I don't see it, but I'm looking for confirmation that there are no other Senate bills on our list that we have not already done something with.
That's correct. Senate Bill 349 is the last vehicle in our committee.
Did you get your question? Yes. Yeah, Representative Carmichael.
You know, it was bad enough that we just failed to pass out, in essence, a bill to provide financial security for the state's contribution to fund the Heartland Flyer. But now to add insult to injury, we now intend, I think, to take the affirmative step one step further. Not only do we not recommend it out, but now we rip the guts out of it to stick in an unnecessary bill because the Senate is going to pass the open records exception. You don't need to do this. We've already passed the extension of the open records exceptions. Where it's going to come above the line. The president of the Senate knows it has to be done. So does the vice president of the Senate. If for some reason they don't get it done by veto session, it'll be Rule 4K and it'll get passed. You don't need to kill the Heartland Flyer in order to get an extension to the records exemption bill. This is a foolish thing for representatives from South Central Kansas to be doing. Thank you.
Do we have any other discussion? Okay, then I'll close on the amendment to put the contents of House Bill 2805 as amended into Senate Bill 349. And I submit that Senate Bill 349 was not going anywhere. That's why we got it in our committee. I don't think we've killed the Heartland Flyer. I think there's a lot of people that are in favor of it. And I think it will live on, as many things do in this building. So with that, I close on my amendment. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. All those in favor of the amendment, raise your hand, please. I count 9. All those opposed, raise your hand. I count 5. Okay, so the amendment passes. Yes, as a no vote on the amendment, Representative Carmichael and Heiberger and, okay, Curtis. Okay. Okay, so committee, now we are on Senate Bill 349. Is it a substitute? Substitute, yeah, for Senate Bill 349. What is your intention of Senate Bill 349? Do we have a motion on Senate Bill 349? Representative Lewis.
I'll move we pass Senate Bill 349 as amended favorably out of committee.
We have a second. Representative Vaughn seconds. Is there discussion on the bill? Y'all know what's in it. Seeing none, all those Representative, would you like to close?
Yeah, close. This is a bill we passed out, the substance of this bill yesterday, so it shouldn't be controversial. And I close.
You've heard the motion to pass out Senate Bill 349. All those in favor say aye.
Aye.
Opposed, no. Of the ayes do have it. We have passed Senate Bill 349. Representative Carmichael votes no. Okay, and Representative Curtis? Okay. All right, thank you, committee. We actually have one more bill that I would like to work. We'll see what your intention is about this bill. It is House Bill 2300. Y'all heard that last Wednesday. Natalie, could you give us an overview?
Thank you, Madam Chair. House Bill 2300 would require a duly ordained minister of religion to report certain abuse and neglect of children, except when reporting, making that such report would violate their penitential communication privilege.
Okay, do we have any amendments on this bill? Seeing none, do we have an intention about House Bill 2300? Representative Vaughn.
Madam Chair, I would make a motion that we pass out House Bill 2300 favorably for passage.
I'll second it.
Representative Lewis seconds. Do we have any discussion? Representative Carmichael.
Thank you, Madam Chair. I do want to remind the committee that we did have discussion from several of the conferees about training requirements, training recommendations, some good suggestions. This really wasn't my bill and wasn't a matter that I'd worked on, so I didn't prepare amendments to the bill. Maybe somebody has amendments. If they do, it'd be nice to have training amendments on this. So I'm not the expert. I hope somebody holds such an amendment. Now, it's not going to stop me from voting for the bill, because I'm not going to let the perfect be the enemy of the good. But we really ought to be covering that in some fashion. I just don't have the expertise to design such an amendment. Thank you.
And I asked for amendments, and I don't believe that there were any. So, yeah, Representative Lewis.
Yes, to Representative Carmichael's point, I have been involved in this issue for a long time, and I do appreciate the issue that you and the conferee raised about the possible need for training. I also talked to several clergy afterwards, and they said that at least in their denominations and their churches, there was already training available. And as I thought further about it, I just thought the time was short to sort through the issue. We hadn't really fully considered it, and so my view is that that may indeed be something that we want to take up in the next term. But given the short time frame here, I thought it best to pass this one as it is and consider that later.
Representative Carmichael.
Thank you. And I do understand the quandary. My concern is not about the large denominations. I've served as counsel. I know some of you may find it hard to believe, but I've served as counsel to my church and represented some not mainstream, but some large denominations, and most of them, because it's the right thing to do and because their insurance carriers require it, do have that training. My concern is about small, non-denominational, non-affiliated congregations. And I think one way or another, we or somebody somehow owes it to those ministers out there to help them understand what is a reportable incident, because they are really placed in a quandary, because they have an obligation of confidentiality toward their parishioners, even if it's not the penitent privilege. And I'm sorry, the word doesn't come to me. It's late in the well, not even the confessional. I mean, if I go to my Presbyterian minister and I say, Pastor, I've done a terrible thing, that is privileged from discovery. But to try to make those fine line distinctions without training for someone who has not been involved in this as you have, and perhaps I and others have been involved, I think we're doing them a disservice to place an obligation on them without putting some structure out there. I think it was Representative Smith, and perhaps he only whispered it in my ear, but what he also expressed concerns about is non-reportable acts incidents being reported because of a lack of knowledge as to what has to be reported and what should remain within confidence. Again, I don't want the perfect to be the enemy of the good. I'd rather have us pass something than nothing at all. But it's unfortunate, in my view, that we're not addressing this. Thank you.
Do we have any other discussion? Representative Mon.
Thank you. I spoke with some of the conferees on this issue before it actually was heard. My first step would be to echo my friend from Wichita's comments, mainly because in my experience, I've seen lots of practitioners, whether they are that are under a requirement of mandatory reporting, not really understanding or uniformly understanding what needs to be reported and what doesn't need to be reported. And so a lot of the times things that didn't need to be reported are reported to the detriment of that practitioner's client. And I know that this bill doesn't actually talk to the pre-penitential exception, but I do think it's important that when people talk to their priests or religious counselors, that they be able to do so in an air of openness, and so that they can be honest, because without that, you can't have a full confession and therefore full redemption. And I just think this is one step towards undermining that penitential sacrament. And as a practicing Catholic, I can't support this.
Representative Lewis.
Yes, to my friend from Wichita, if you look at the second page, big G, we accept, it says that any duly ordained minister of religion, as defined by ASA 6429, thereto is a mandatory reporter, except that a duly ordained minister of religion who suspects abuse or neglect based on a penitential communication is not required to violate the penitential communication provision. That protects that circumstance.
And Representative Lewis, I do understand that and see that and read that, but I just see this as a step towards undermining that protection. And I understand that we've tried to protect it in the language, but for me, it's we're just too far. So.
Representative Lewis. Yes, Lewis.
Just I'd point out that the Catholic bishops are proponents of this bill, even though they didn't speak to it. They did have written proponent testimony.
Representative Carmichael.
Thank you, Madam Chair. Appreciate the second opportunity to address this. Just very briefly, for the benefit of those listening online who think we are lawyers and think we should talk like lawyers, it's KSA 60-429, and it is called the Penitential Communication Privilege. And it applies to priests, it applies to imams, it applies to anyone who is, and I could read the entire thing, but I just want to make sure people understand that that privilege is not just related to the Catholic Church, the Presbyterian Church, or the Unitarians, or Islam, or whatever other religious belief people might have. It applies to all of the people who provide that type of religious service.
Okay, committee, is there any more discussion or questions on this Senate bill, or sorry, House Bill 2300? Okay, Representative Vaughn, would you like to close?
I close.
All those in favor of passing, you've heard the motion, all those in favor of passing House Bill 2300 favorably for passage, say aye.
Aye.
Opposed, no. House Bill 2300 is passed favorably. Out of passage, out of committee, Representative Heiberger and Carmichael are a yes vote, and they would like that recorded. Okay, committee, wow, thank you so much. That was great work. This is the end. Bravo to our staff who have gone above and beyond. Thank you so much to them. Thank you so much to all the committee. Really appreciate it. And we'll see you next time, whenever that is. Okay, bye-bye.